hear from Mr. Herrera. It's just a status, so I can appear,
Mhm.
Oh, well,
but I
I'm
will tell the
happy to
court I
wait.
don't really know what's going on.
I'm happy to wait. If he's logging in, we'll keep our eyes peeled. We are set for a final status conference. You're set for trial May 15th. Who wants to give me an update?
Absolutely, Judge. And I think uh, as Mr. Herrera and can attest to, we've been having conversations with Mr. Hernandez to schedule some remaining depositions that are needed, as well as trying to get a mediation set, Judge. I think there was expert designations that the defendants just did recently. And I think we're trying to get everything we can, Judge, just based on the last minute things that were done, because I think the expert designations for the defendants were earlier this month. Um, I think on March 4th, so 2 weeks ago. Uh, Your Honor, I think we just may need like 2 more months additional just to like complete those, because there was a lot more experts than I was anticipating on the defense, but nothing out of the ordinary. Mr. Hernandez and I we've been working well on this, so I think we just may need a little bit more time on that. But I think, especially we're trying to coordinate a mediation with Mr.
With
Gato.
the hat on. This guy, it's
Civil?
bring him over.
Okay, hold on, Mr. Nunez, let me mute you. Okay, so, so when you're asking for a little more time, let me ask, are you gonna meet your mediation deadline of April 14th?
I think we're just trying to coordinate the date with Mr. Cardenas and everybody's representative. That's usually the holdup. I think Mr. Lopez can probably attest. It's a lot harder to get a representative to from the company to agree to find time, but that's not an issue, Judge. I think we're just trying to get everything we can.
Okay, so I mean, if I'm hearing that we're trying to make the deadline of
Yes.
April 14th, then nothing changes for my purposes. Good luck to you all working on that. I'm going to check in with you all on the 15th to see if we were successful at mediation or if we're going to look at something else. Okay?
Okay.
Sounds
Thank you
good,
very
Judge.
much for your time. I don't know if you all have other matters. If you don't, you are excused.
Thank you, Your Honor. Thank you, Judge.
Thank you, Judge.
Now
I think
let's thank
right,
Monday.
that might be it. So thank you.
Okay, thank you too. All right, I'm seeing in the chat, let me see, going back to Mr. Sanchez and Miss Stanton. I have April 16th, 2027 trial date.
That works for the plaintiffs, Your Honor.
That works for us too, Your Honor.
Thank you very much. We will circulate the scheduling order. You're free to create your own scheduling order as long as it has all the information that's in ours. Agree to a mediator, return it to the court within 2 weeks. And you will not have to be present for the entry of that scheduling order. If we don't have it, then I need you all to appear. Anything outside of those dates, please make your request with the court with your filed pleading, and we can set you for a hearing, okay?
Yes, Your Honor. Thank you.
Thank you
Your
for your
Honor.
time. You all are excused. All right, let's go to what I think, is everyone here on 3013?
Yes, ma'am.
Mr. Skipworth, yes. Calling cause number 2024 DCV 3013, Margaret St. Cyr versus Drill Tech LLC. May I have announcements, please?
It's Robert Skipworth on behalf of the plaintiff.
And Your Honor, Laura Cabuto on behalf of the defendant, Drill Tech.
Good morning. Final civil pretrial. Why does this case ring a bell, but like not really substantively? The name.
Well, Judge, lately my client had to undergo open heart surgery, and the court continued what was on the docket at that time. I forgot what it was. And I have talked to her recently. She's in the recovery mode. She's ready to go, but has to catch her breath just to come to the phone. So I'm not sure she is ready to go. But and then Ms. Cabuto has filed a third-party complaint against the subcontractor who was on the job, and I don't know what's happened on that.
Your Honor, the subcontractor was served by substituted service because we were unable to do so traditionally. And his answer, or the entity's answer, was due this past Monday on March 16th. There has been no answer as of yesterday. So That's where that is. I mean, I can file a default judgment, or if the court wants me to wait a little bit, I can do that. But we have that third party defendant that we feel is a necessary entity to have in this case.
So I think I remember, at least from the continuance, that although I granted it, I thought it was unclear, but let me double check. If we were, are we still asking for a continuance of the April trial setting?
We are, Your Honor, I believe. Is that right, Mr. Skipworth?
Yeah, I would have to, I don't think my client is ready to go through the rigors of a trial.
And that's where I think I just maybe was being a little nitpicky because I wasn't sure if it was that or just for the next setting, but I certainly understood the circumstances. I don't have an issue if you all, well, how would you suggest? Here's what I could do. I certainly can't reset you for trial that quickly, if that's what you would be asking for. And I don't know with this additional party, if you would like a bit of a window, maybe something like 60 days, and I'll set you for a scheduling status conference, and then we'll go from there. But understand that that really does mean that we're probably looking at least April 2027. Or I could just set the trial date now. I mean, if you'd like to do that, I don't know if it makes any sense to wait.
Well, I don't believe we've ever been to mediation on this case, have we, Ms. Caputo?
We have not, Mr. Skipworth.
Would you
I
like?
think we should try mediation, try to get rid of this thing, and then
Well,
and we
well,
could do
90
that within the 60 days.
60? Okay.
Your Honor, my only concern once again is there is a third party defendant that was brought in that has a contract that was supposed to defend and indemnify my client. So I don't know if setting it for mediation within 60 days is going to be fruitful considering my client's position.
Yeah. So I think and I'm happy to shorten the mediation deadline, but I think I'm going to just give you a new trial date a year down the road, and you have the deadline as yesterday was the deadline, mediation deadline under the current scheduling order. We'll do a year out. We'll do that April 16th, 2027 trial date. And, you know, we'll have new deadlines, but certainly it's a big enough window that you all can attempt mediation whenever you think it's ripe to do so within the new deadline. That's how I see it.
Okay.
So that's what we'll do. That's our new scheduling order. I mean, that's our new date. That's our new trial date. If you all would return a scheduling order, and if you need anything outside of those hearings, we'll go from there. But just know that this April 2026 current settings are now canceled. Okay.
Thank you,
Okay.
Judge.
Thank you for
Thank
your
you, Your
time.
Honor.
Appreciate you all. Take care.
We
You all are
excuse.
excused. Yes, ma'am. Okay. Now where are we headed, Mr. Nunez?
Judge, bottom of page 4.
Mhm.
Calling cause number 2024 DCV 3941, Erica Herrera versus Aaron Quevedo. Announcements, please.
Michael Gomez for plaintiff Erica Herrera.
Judge, I reached out to
Bradley?
Mr. White's office and advised him he needed to be on, and they could not connect me to him.
This is Randy Grambling. Is that for Sean White?
Yes.
Yes.
Yes, I'm sorry, I didn't hear the name of the case.
So this is Aaron Quevedo and Franklin Mountain Coffee Company scheduling
Okay.
status conference.
Yes,
Okay. So, you all are gonna know the date. You want April 16, 2027?
that's fine.
That works for us, Judge.
Okay. That's what we'll do. Please return the scheduling order. You all know the drill. And we'll see you next time. Please include your mediator. Thank you very much.
Thank you, Honor. One more.
One more. Hi, Mr. Grumbling. Okay, who's next, Mr. Nunez?
Judge, on page 5, calling cause number 2023 DCV 0040, Jasmine Silva et al. Versus Albino Rangel Ramirez et al. Announcements, please.
Jeff McElroy with Labinati Law Firm on behalf of plaintiffs.
Your Honor, Aldo Lopez on behalf of the defendants.
Bear with me one second. All right, final civil pretrial. April 17th. Is everyone ready?
Your Honor, we would like to ask the court if the court would order us back to mediation. We closed the gap at the previous mediation, and there's still some room to be had. There was a mediator's proposal, but we would like to see if we can mediate one more time in person before this case goes.
Mr. Lopez, what's your position on
Uh,
that?
Judge, I'm not opposed to it. I know I've spoken with Miss Labinati. She's also spoken to with one of my partners, so we are getting closer to an agreement. I'm actually waiting on a response from my adjuster to see if we can get it, you know, possibly get it resolved. As far as the trial date goes, the attorney handling this, Rebecca Alvarez, left our firm in January, and so I took over the case. I'm scheduled to be in trial in the 41st on April 10th for a 3-week trial. So we were gonna we were gonna ask for the
So look,
the for the trial date to be moved due to that conflict, and just because that's a 2015 case that was tried once, has gone up on appeal, and has come back down.
Broad Street?
Yes, yeah, Jeff, it's back.
I'm conflicted on that one.
Um,
Oh my gosh, that case is still around?
It
I'm
is.
sorry, Your Honor.
Sorry, Judge. I would be open to agreeing to a mediation, Judge.
so let me ask Mr. McElroy, are you okay? Are you in agreement with a continuance?
Well, Your Honor, I would like to leave it on the docket just a little bit longer and see if that case does go. That case is, I know that case, not as well as I did 5 years ago, but I do know that case, and I have to think that there's a chance of it settling. So unless Mr. Lopez wants to urge it on the grounds that he's just new to the case, and if so, I would just let the judge rule on that right now.
So what have you guys looked at dates with mediators? Like, what is the chance that you're going to get a mediation date if I ordered it before the 15th of April?
Well, since Mitch Moss was our first mediator, I would say, Judge, that that's probably less than 25% that he would have something open. But sometimes you can beg Mitch, and he will finally find space for you on a mediation schedule. So I think we could, if our feet were still held to the fire. But in terms of really getting it off your docket, I think we have a better chance if we leave it on the trial docket for now, understanding that Mr. Lopez may want to re-urge that motion for continuance, and I don't know that the grounds he has are that poorly founded. But I think going to a mediation, if we can get one scheduled with the trial still on the court's docket, gives a little bit more incentive to try to come with the best negotiation position possible.
Yeah. So when was your last mediation?
it was in October, Judge.
Mm.
That was with the prior counsel, and then we've just been doing informal settlement talks since the beginning of the year, Judge.
Here's a little bit of, my concern. I get it. I mean, I'm hearing motion for continuance, maybe another shot at mediation. But your deadline was yesterday, and I guess you met your deadline if you mediated back in October. But
We did, Your Honor, and we were aware of that, and we were hoping that mediation deadlines are something that we've committed as a firm we're never going to miss again. We were hoping that since we decided we need a second mediation, that it would just be deemed to be a continuance of the first mediation.
yeah, but it didn't get set before today. And
correct,
so
but we did have one. Yeah.
Yeah, no, I get that, but here's what I'm going to say. Mr. Lopez, if you're asking for your continuance, file your motion. I don't have a problem saying, order you to mediation by April 14th. I mean, it's just an additional 30 days from the original deadline. So there you go. So get me an order, file your motion, Mr. Lopez. I understand what Mr. McElroy is saying. I don't like being, You know, I don't want to find out on the 14th that you all are ready to go to trial and, you know.
So, of course, Judge. And Judge, I know Mr. McElroy asked for an in-person mediation, just
Mhm.
with the time frame, and for us, we have the insurance adjuster, so I'd ask for my adjuster to be able to appear remotely.
Mr. McElroy?
Well, Your Honor, I just don't think that there's as much chemistry between the mediator and the adjuster in terms of, perceiving. I have better success when the adjuster's here. That's the best way to say it.
So in light of the time constraints, the court will allow that adjuster to appear remotely. Mm-hmm.
And Your Honor, this is a heavy property damage case. It's not it's not one that I think, well, I'll just say it's one where the car was crushed. So I think if we get to that mediation, there shouldn't be any impediments to us hopefully resolving it.
So we're going to continue this final civil pretrial to April 8th at 10 a.m. Okay, so I can check
Yes,
on
Judge.
status.
Will we
Thank
get
you.
a notice of that, Your Honor?
Yes, sir.
Okay, thank
So
you.
April 8th. Thank you.
Jeff, do you want to reach out with me for potential dates?
Yes, I will do that.
Okay.
You, I'll call you in a little bit, Aldo.
All right, thank
Mr.
you.
May we
Hernandez,
leave, Your Honor?
yes, have a good day.
Thank you.
Mr. Hernandez, were you here on the previous case that Mr. Lopez so kindly?
Yes, Your Honor. I just wanted to apologize to the
No,
court for being tardy.
no
I was 5
worries.
minutes late, and I'm so sorry about that.
No worries. You're good to go. I just saw
Thank
your name there, and so I want to make sure if you were here for something else, I wasn't kicking you
I,
out.
I put myself in the corner just for that, Judge, and I just wanted to make sure I could get out.
Okay. Take care, guys.
Thank you,
Have a
Judge.
good one.
Thank you, Judge.
Bye-bye.
Okay. So who's next?
Judge, the rest of page 5 is the non-suits. So we're moving to page 6. And Mr. Beganowski's here. Calling cause number 2025 DCV 2633. Mary William Salzman versus Michael Michelle Rifa. Announcements, please.
Your Honor, this is Zach Biganowski representing the plaintiff.
Good morning. Let's see, status conference. Do we
Yes.
have?
And Randy Grambling is representing one of the defendants, Your Honor. I think he just stepped away for a moment.
Oh, Mr. Grambling. Oh, yeah. I see his. Okay, I thought he's still there. Okay, but he's not there. Okay.
Yes, Your Honor.
Let me see, status conference. Let's see, answer.
I can give you a brief rundown, Your Honor, if you'd like.
Mm-hmm.
Okay. So, Michelle Rafai, who's the first named defendant on this case, it took some doing, but we finally got her served on February 11th of this year. My client had a fall in September of 2024 at what used to be a restaurant on the west side of El Paso called Block Table Tap. Since that time, it has closed. So it took some due diligence on our part to find out who the owner was at the time of her fall. And that's why Miss Michelle Rafai is named as the first defendant. Since that time she's been served, a representative of hers has reached out to me and we've spoken a little bit more, and they let me know that there were other owners at the time of the fall and who the property owner of the commercial piece of real estate was at the time of the fall, who is Goldberg Family LP, which is why plaintiff has supplemented their petition and included them as a defendant as well. And they just answered as of yesterday, Your Honor. So if we get another status conference within 60 days, I'm positive that after initial disclosures and conversations, we'll get all the people that are supposed to be in the suit in it and well underway to getting it resolved, Your Honor.
I was hoping Mr. Grambling was going to float back in, but I
Me
haven't seen
too.
it yet.
I tried to elongate my speech as much as I
Mr. Grambling, you're unmuted. I don't know if you can hear us. So I was going to say 30 days, but if you think 60 days will work.
whatever the court would like, Your Honor.
30 days, and we'll do 60 days. All right. Mr. Biganowski, if you'll just go ahead and stick around
Sure.
60 days and see if Mr. Grambling comes back.
Yes, Your Honor.
All right, who's next? Anyone else ready?
Judge, let me see if Ms. Huff is covering the next one. What are you here for, Ms. Huff?
I joined a second early. I'm here for MFI. Is the defendant, 1 second. My client,
Give your cause number, ma'am.
yes, sir. Cause number 63436. That's not your cause number, that's on mine. I'm so sorry. Give me 1 second.
Ma'am, let me ask you, are you here for Velocity Investments? Or Chris Credit Shelter?
No, sir, I'm here on Politel SADCV versus MFI International Manufacturing.
I don't see that one.
Cause number 2025 DCV 1475.
I don't see you on the docket, ma'am.
Thank you.
Twenty 2025 DCV 1475 is out of county court at Law 6.
Judge, we still have one more minute before we can call the
I think everyone
Chris
is
Credit.
here. Did everyone? Oh, no, I'm sorry. I was talking about Courageous.
Yes, ma'am. On page 7?
Yeah.
Is someone here on 2582?
No, ma'am.
No, so we'll come back to that one.
Yes, ma'am.
And then anyone here on Velocity Investments?
That one also, no one, Judge.
No one. Okay, so let's move. I think Mr. Grambling.
I had another hearing at court 6. I
I'm
went to another
so
computer. Now I'm
sorry.
back, Your Honor. We're here for the
Mr.
Goldberg family.
Yeah, so we're gonna reset 60 days. I just didn't want to because you were still here but not here. I didn't want to leave you out.
I'm sorry. I ran
Are
to
you
another
good?
computer and now I'm back.
60 days. We're gonna reset for 60 days.
That'd be fine. Thank you, Your Honor.
Okay, thank you. Now, if you don't have anything else, you're good to go.
Have a great day.
Thank you. Have you too. Yes,
Thank you.
let's go take care of 2183 since everybody's here. I
Yes,
think
ma'am.
everybody's here, at least by my count. I'll call it.
Yep.
Calling cause number 2025 DCV 2183, Annie Courageous versus Christian Anthony Olivo et al. May I have announcements, please?
Your Honor, oh, I'm sorry. Good morning, Your Honor. The movant, Jess Mason, on behalf of defendant Rico Spirits.
Your Honor, Pablo Lopez on behalf of the plaintiff, Annie Courageous.
Your Honor, Carlos Rincon for Mr. Olivo.
Good morning, Your Honor. Patterson W. Kime for the defendant, Midier Olivo.
Good morning, Your Honor. Cote Baza on behalf of Tequila General Forios Dieta and Don Vicente Tequila LLC.
Good morning, Judge Joshua Murphy on behalf of Yi Group LLC.
Okay. So is this the first hearing I'm having since you all came over?
It is, Your Honor. You inherited this case, and
I
this is
inherit a lot of stuff. I get transfers, I get all kinds of things. That's okay. But
Yes, Your Honor.
I was reviewing and I wanted to make sure, and I believe Mr. Kime, your recent entry, or at least maybe at the time it was transferred, is that, but we're here, yes, on Mr. Mason's motion in support of attorney's fees. Is that right? So I had a notation or an email, Mr. Lopez, I think, that there was a withdrawal of the default, which is kind of like the first thing it was set on. That was with respect to Mr. Kime's client, if I'm not mistaken. But we are here on the motion in support of attorney's fees on the motion to dismiss that was denied in CC 6-3. One of those.
Yes, Judge. So I had two motions, the motion for default judgment on P.L. Howard, which we withdrew for today's consideration, and then the motion in support of attorney fees on Yes, the previous motion to dismiss, the 91A motion to dismiss.
Okay.
And then Mr. Mason has his motion to compel.
So let's start on the attorney's fees. And just indulge me with a little bit of background.
Yes, Your Honor. So this lawsuit arises out of an accident that occurred more than a year ago, on March 15th of 2025. And my client was driving on Red Road, west of I-10. She was driving west at night, and at such time and place, the driver, Mr. Christian Anthony Olivo, was driving on the opposite side of the road, going the wrong way, and collided head on with my client, Annie Courageous. Mr. Olivo, after the El Paso Police Department arrived at the scene, was placed under arrest for intoxicated assault with a vehicle. And he's facing pending criminal charges for that accident. At the same time, when Mr. Oliva was being questioned by the police, and before he asked for his lawyer, he revealed information that is part of the basis of why we're here. Mr. Olivo identified that he was at a tequila tasting event at Barol Restaurant moments before the crash, or immediately before the crash, that there was tequila tasting, and that he had had alcoholic beverages at such time and place. The suit was filed, and we've, in conducting discovery, we confirmed that there was a tequila tasting event at that place, that the respective tequila companies that are here with their attorneys were at that event promoting, serving alcohol, and marketing their brands. And then they created the situation by having Mr. Olivo serving him, alcoholic beverages to and past the point of obvious intoxication. At the same time, the officers also, in their investigation, revealed that Mr. Olivo was carrying tequila bottles at the time of the incident. Now, whose tequila bottles they belong to at the moment is unclear. I took the deposition of Mr. Olivo about a month ago, and he pleaded the fifth to every single question. And so no substantive testimony has been had when it comes to Mr. Olivo's testimony. And he has his absolute right to the Fifth Amendment, but when it comes to the actual succession of how the events unfolded on that day, there hasn't been that much substantive discovery other than what the defendants have produced. And so that's why we're here, Your Honor. That's why the lawsuit was filed, and that's why the parties involved are here.
Okay, but with respect to the motion to dismiss?
And so, Your Honor, with the respect to the motion to dismiss, Ms. Mirella Olivo was sued in her individual capacity. She was the lead at the tequila tasting. She also operates an Instagram account, which is linked with a Square link for payment, and operates a business under the name of La Tequilana. And she provides the services of going to events and leading the tasting of the individuals at the event on what type of tequila they're going to try, or what type of tequila to try, not to try, what type of techniques to use when drinking tequila. And so Ms. Oliva was sued in that capacity, individually and doing business as La Tequilana. And at the time she was sued, 90 days after she was served, she filed a 91A motion to dismiss, which Judge Baeza, CC3, before the transfer, denied. And it was before Mr. Keem's involvement and Scott Holtz's involvement as well. At that time, Ms. Oliva was pro se. And so she filed this motion. I had to file my answer, do research, go to the hearing, and draft the motion as well as argue it. And so in support of that, Your Honor, we not only answered Ms. Olivos's 91A motion to dismiss, but we also asked for the attorney fees because the rules provide that the prevailing party on that motion is entitled, can be entitled to attorney fees. And in support of that, Your Honor, we've submitted my affidavit saying the time I spent, my the time I spent in drafting the lawsuit, the applicable rate for my time and my abilities and my time here at the firm and as a practicing attorney. And so we filed this motion in support of the attorney fees that we requested at that time. At the time we filed the response, we didn't attach an affidavit, but thereafter I filed my motion in support of the attorney fees, Your Honor.
All right. Is there what I was trying to look up, and I'm not seeing, maybe I'm overlooking it, is a response on the attorney's fees?
Yes, Your Honor. So there's not a response as of now. My records might be incorrect, Your Honor, but as I understand today, this hearing was set on the default and on one of my co-defendants' motion to rule objections. To my knowledge, I haven't seen a notice of hearing for the attorney's fees on this date.
Okay, let me look at that. I can tell you I'm going by just the notation on my docket that did include the motion in support of attorney's fees, but let me actually look at a notice of hearing, if there was a notice of hearing. Not that one. Order setting hearing, look at that one. That's just the default. Ms. Uran or Ms. Nieto, do you show any notice? I've gone through 3 and I don't see one on the attorney's fees other than the notation that's on the docket, but do I actually have a notice to the parties that this was going to be heard today?
So right now I can't see one either, Judge. I'm unable to locate one either.
So, my apologies.
No, Your Honor, and I think that note was copied over from the original setting.
From CC3?
Yes, Judge.
Okay. So let's just wipe the slate clean and get it set and make, I'm happy to take it via submission unless you all are requesting a hearing, but we can do the hearing as well. It just won't be today, Mr. Lopez. So we'll
Okay,
get
yes.
actual notice out. You can anticipate it in about 30 days. And I tell you that just because of the court scheduling with holidays coming up, that's when we could do it. In fact, I would ask Mr. Lopez if you would kind of initiate that request with Ms. Nieto, so we're not carrying anything over from any other court and we're getting proper notice out. Okay?
Absolutely, Your Honor. Thank you.
Thank you very much. Now, so we'll table that. And Mr. Mason,
Yes, Your Honor.
You were stepping up on the motion to compel.
Yes, Your Honor. We've got a motion to overrule objections and compel the plaintiff to respond. Your Honor, first of all, let me apologize for having to bring this motion. It's I know discovery disputes are probably not the court's favorite activity, but in this situation, Your Honor, we had a response filed by Mr. Lopez to each and every one of our interrogatories and requests for admissions with standard precatory boilerplate objections to overbroad, ambiguous, vague, unlimited in time and scope to absolutely everything. This is specifically forbidden under 193.2E, what us old timers refer to as the new rules, but and I'm probably the only one on this at this hearing old enough to remember it, but the Supreme Court got fed up with how people were lodging these objections to every single thing, and then sometimes answering, sometimes not, and then sometimes hiding behind the objections and avoiding response. So that's the genesis of 193.2E. Whereby if you engage in that sort of behavior, you actually waive your objection. We think because that's exactly what they did in objecting to every single request and every single interrogatory, regardless, that they have in fact waived all that. There was not a response filed, although while Mr. Lopez was speaking, my secretary sent me a text and said that they just filed something. I haven't read it. I don't know whether the court would consider it. If you need me to go through these one by one, I certainly can. I would let the court know as Exhibit C to my motion, I sent Mr. Lopez a 14-page letter whereby I specifically identified all the defects in his responses and asked him to withdraw those and fully respond. Certainly, he's welcome. He was welcome to call and speak to me and try to work through it. He elected not to do that. He has not contacted me at all, and like I said, there was not a response filed, at least not a timely response filed. So I have a very specific order, Your Honor, with each and every request for production and I didn't put them all on here. I just put the ones that I thought, these are really these are ones that I think are legitimate, and I think the objections are unfounded. And so I've listed those in a very comprehensive order with for the court that has columns of overruled, sustained, or modified, depending on the court's ruling. So I don't know how you'd like to proceed, Your Honor, but I'm prepared to do whatever's best and most judicious for the court.
So as I was hoping I wasn't interrupting, I was listening, but that's what I was printing out was the response that I see that was filed today, which I like you have not reviewed. Mr. Lopez, what do you have for the court?
Yes, Your Honor. So in addition to the response that we filed, and I apologize for the late filing of that. It's been one of those weeks, but in addition to the objections we lodged at the time we filed our answers to the discovery, which we think are proper objections to the questions and the way Mr. Mason has phrased the request for production and or request for interrogatories. A lot of those requests, Your Honor, go to any and all and have no limiting time of scope or time. And it involves either sources that are not subject to my client's control, possession, or custody. And so because of that, Your Honor, throughout the discovery responses, we lodged those objections as they were proper under the rules. And based on the answers, based on the request as phrased, some of them were just vague, overbroad, and some of them I did not understand, Your Honor, the extent to which Mr. Mason was seeking documents or production for, as well as the interrogatories. And so, and yes, we can go through the individual discovery responses. I mean, I want to use the court's time judiciously. So if that's too much, then we can go in through the categories of the different types of requests and the different interrogatories, Your Honor.
Your Honor, I think maybe there's a fundamental misunderstanding here, because if you don't have documents, the response should not be an objection, which obscures whether or not you have them. It's just we have no documents. There's none. I'll give you an example, Your Honor. On page 9, for example, of my motion, on interrogatory number 6, I asked for her to describe the activities the day of the accident from morning till the time of the accident, which was about 11 p.m. And the reason there's no mystery here, Your Honor. The reason I am asking for that is because she also had been drinking and had an elevated BAC, and we're not sure whether it was in excess of the legal limit or not, because while it was about a point 0.6, the blood draw was hours after the accident. So she may literally have been intoxicated herself. That's something Mr. Lopez forgot to mention. So I asked, what'd you do that day? Because I'd like to know if she was at a bar, she was at a restaurant, was she, where was she drinking? Because she certainly was drinking. In response to that, I get an objection of overbroad, vague, ambiguous, and harassing. The next one, right below that, number 7. Please state how you contend the accident occurred. I get an objection. Instead of saying, here's how it happened, I was driving down the road and, the car hit me, I get, overbroad, unduly burdensome, requires speculation, is premature, et cetera, et cetera. It's just constant. And even the simplest of these requests, for example, on page 3, I ask, please produce documents or evidence that you have your activities of the date of the accident. Again, I'm looking for what she was doing the day of the accident because we know she was drinking, where and how much. Instead of responding, I get an objection for overbroad, ambiguous, unlimited time. He's claiming it's unlimited time when the time is specified right there, the day of the accident. So if you look at this, Your Honor, there's just consistent objections, the same thing without regard. And I can't tell whether or not he's withholding documents or not, because it's all subject to this objection. I'm entitled to sworn answers on the interrogatories, which I didn't get. I mean, I'm not to say that she didn't file a verification. She did, but in response to some interrogatories, she incorporates her initial disclosure, and that's not sworn to. So just candidly, Your Honor, I don't think much attention was paid to responding to this discovery. We're entitled to it. We're entitled to this information. It is discoverable. There was a refusal to produce anything or answer anything with regard to whether or not she has any criminal convictions. I'd like to know if this woman's got DUIs or DWIs, because again, she's been drinking, and so they're just hiding behind all these objections, and I can't get to the bottom of it. I don't like filing these motions, Your Honor, but I just have to, I guess, get a proper response.
So it didn't sound, I mean, I don't know. It didn't sound like you all had conferred. I'm not saying attempts were not there, but that there wasn't any discussion to whittle this down. Frankly, I would probably need a minute to review certainly the response that was filed today, and then look at these, because just going on the ones that were highlighted thus far, I have questions, and it might be that we're going to go one by one, but kind of being respectful of everyone's time, I think I need to look at them. Mr. Lopez, you can give me an initial response if you'd like, but frankly, I think I see this being reset at least 1 week, if not 2, if you all can't come to some type of an agreement. And then we may have to go one by one, but I'm going to look at them one by one, and I'm happy to rule via submission based on what you have. So,
And Your Honor, if Mr.
Your Honor,
Lopez would like to contact me, I'd be happy to do it. In fact, Your Honor, when I filed my 14-page letter identifying everything, rather than responding to that, I got a letter back from Mr. Lopez complaining of my discovery to him, my objections. And so, doing what I think should have been done in this case, I looked at my responses and said, I think this is a proper objection, but who cares? And so I waived a bunch of my stuff and amended my answers. If Mr. Lopez would like to try to discuss this, but I would like us to reset this, Your Honor, and I certainly respect the court's time because there is a lot here.
So I don't know if you had anything to add to that, Mr. Lopez.
Your Honor, I agree with the assessment that if this can be reset, that way myself and Mr. Mason have some time to boil all these requests down to the ones that we cannot absolutely agree on for your court's consideration. then I think that would be the best use of everyone's time, including this court as well.
So I think, let me look at the date. How does April 8th look, Marissa, in terms of in the event that we are going to have to go through and maybe not go through each and every one, but saying there's still a good amount left to dispute. What does the 8th look like? We've been doing all these little special settings because of just a lot of work. Yeah, April 8th looks good, I think. In the morning.
Yes, Your Honor. I mean, there's some time before the 9:45 hearings.
Yeah, we didn't put our first case today on the 8th.
No, you gave them Monday the 6th.
Let's just fill up that first week. Let's do the 8th at 8:30. And that is going to be the hearing on the attorney's fees. And that's going to be the hearing on this motion to compel.
And Your Honor, to take that, is it possible to also set the default on that date?
I thought it was withdrawn.
The consideration, I don't, just because for today's hearing, it was noticed, but our service processor wasn't able to hand out the notice to the last known address of the defendant via certified mail. And so I want for it to be in accordance with the rules, and that the defaulted party would have actual notice of when the hearing would take place. We did.
So you were just asking for the hearing to be canceled. You weren't withdrawing
Reset,
the
yes.
motion. You're not withdrawing
Yes.
the motion for default.
Yes.
Ah, okay.
Yes, Your Honor.
Okay, so it's not, motion is not withdrawn. You're asking to reset. Okay,
And
so
Judge, in addition to that, this is Attorney Joshua Murphy. Could we have our motion to withdraw set on that same date so we can provide the proper notices to the defendant?
sure. Okay, so I have a
Thank
motion
you,
to
Judge.
withdraw by Mr. Murphy. Is that right? And then a default, Mr. Lopez, reset from today. Then we have our motion on the attorney's fees on the motion to dismiss and the motion to compel Mr. Mason. All set on April 8th at 8:30 a.m.
Mountain time.
Mountain time. Via Zoom. What else? Anybody else have
Your Honor, would
something
you?
else?
We'll I'm sure Mr. Lopez and I can we'll speak this week, and if you want, I'll submit a amended order or another order that'll reflect what if we're able to reach agreements, and then I'll leave it in the same format that you just printed off, because I think that's probably the best.
That's fine. That'll
Okay.
work. Anything else for today?
No, Your Honor, not from me.
Mr. Rincon, I didn't hear from you. I didn't hear that.
You know,
Your name?
it's fantastic to be on the sidelines watching these great lawyers do their job.
I appreciate all of you. Thank you very much. We'll get you reset accordingly.
Thank you
All
for your
right,
time,
Judge.
Your Honor.
Have a great week, Judge.
Thank you so much. Bye-bye. Thank you.
Thank you, Judge.
All right, Mr. Yage, are you here on, let me see something that was
On page 3, Judge.
page 3, Mr. Yage. I think we just needed an order on your non-suit.
Hi, Your Honor. Good morning.
Hi.
Sorry,
Hi.
I've been
No worries.
I've been tied up all morning in
No worries.
hearings and back and forth. I apologize. I should have let the court know of my conflicts with other courts.
No, send me an order, please.
Yes, I will do that, Your Honor. Thank you very
Okay.
much.
Thank you. Have a good day.
You too. Bye-bye.
Bye-bye. Mr. Reedman has been waiting patiently.
Yes,
and
ma'am.
he's
And
been reset Monday. Yes,
I've got pro se in this one too in the waiting room, Judge.
Mr. Reedman, good morning.
Good morning.
So yours, I remember especially because I think it came up twice and got bumped because of trial, if I'm not mistaken. And we had,
I don't think so.
no?
No.
Okay, then I'm wrong.
It's
Yeah,
on
that's
Chris
all right.
Credit, Judge, on page 6.
Mm-hmm. Are we ready?
Do you want me to bring in Mr. Eric Chris?
I guess so. Is he part of this hearing?
Yes, ma'am.
Mr. who?
Eric Chris. It's on Chris.
Oh,
Credit.
Eric Chris, that's my witness.
All right, you want to call it Mr. Nunez?
Yes, ma'am. Calling cause number 2025 DCV 2582 Chris Credit Shelter Trust et al. Versus Chris Joint Venture et al. Announcements, please.
Lane Reedman representing Chris Credit Shelter Trust.
And we are set for a motion hearing. Ms. Nieto, would you bring me the envelope and I believe the order that is sitting on your desk?
Yes, Your Honor.
We're set for motion hearing. Mr. Reedman, you may proceed.
Your Honor, this is a motion for default, and I would like to call Gloria Chris to testify.
Ma'am, can you hear me? If so, if you would please unmute your device. Ma'am, if you would please raise your right hand. Do you swear or affirm any testimony you provide will be the truth and the whole truth?
Do.
Thank you very much. You can put your hand down. I will ask if you'll just speak a little bit louder. Can you hear me okay?
Yes, Your Honor.
Okay, if you could just speak a little bit louder and state your name for the record.
I am Gloria Chris.
Thank you very much. Mr. Reedman, you may proceed.
Okay, I'm going to speak loudly because Miss Chris is a little bit hard of hearing, I understand. Miss Chris, are you familiar with the real property located at 125 Thunderbird, El Paso, Texas?
Yes, I am.
And with your permission, I'm going to refer to that as simply the property rather than going through the address the whole time. Is that okay?
That's fine.
Okay. Can you tell me what's on that property?
Some commercial offices.
Okay, it's a strip shopping center. It's got some offices and some retail stores also, correct?
Correct.
Okay. And are you an owner of that property?
I am.
Okay, and you're claiming at this point to be an owner of that property through the Chris Credit Shelter Trust, correct?
Correct.
Okay. You became an owner of the property back in 1974 when your mother transferred some half of the property to you, correct?
Correct.
And if you will look at Exhibit 1, if Eric will get you Exhibit 1.
Oh, yes.
That appears, well, just tell me what that is.
Yes.
You want some help?
You can read it.
I can read, yes.
Speak up.
You want me to address that?
Yes, I mean it looks like Josefina Baiza or Josephina Baiza conveyed some property to you.
Yes, it was my mother.
Okay, so your mother conveyed 0.4045 acres of land to you.
Correct.
And that's part of this land, correct?
Yes.
And now if you could look at Exhibit 2.
Could you show us Exhibit 2 on the screen?
Are you able to share your screen, Mr. Reedman? Do you have the?
I do not have that done. They do have Exhibit 2, 1, 2, 3, and 4. And I provided copies to the court yesterday, certified copies of 1, 2, and 3 anyway.
I just need to know that Miss Chris is actually seeing the document.
Just a moment. Just a moment.
Do you want me to resend that to you, Eric?
Could you do that, please?
I apologize, Your Honor.
That's okay.
Okay, I have resent them.
And just as an aside, Mr. Reedman, you did provide some documents, enumerated 1, 2, 3, and 4. Are these these are exhibits, correct, that you're offering for this hearing?
They're exhibits 1, 2, 3, and 4. 1, 2, and 3 are certified copies, and 4 is not. But yes, they're exhibits that are going to be presented. In fact, I will offer them right now if you want me to.
So I believe you were asking Miss Chris to look at 1, is that right?
Originally, I asked her to look at 1. Now I'm asking her to look at 2.
Okay, there. Are the 2 part of that larger document, the Josefina Baisa conveyance?
Yes, to Ruben Montelongo.
Okay, so that was attached to that.
They're all in one.
They're all in one, so my
They're
mistake.
all in one. I didn't separate them out.
My mistake. It was part of that, so we do have it.
You have, Miss Chris, do you have in front of you a document? I want to confirm. I did not hear her speak to 1. Do you have a document in front of you marked as an exhibit 1?
Just a moment.
Yes, Your Honor.
And what is that?
You want me to read what's on it?
I just want you to tell me if you have personal knowledge what that document is.
Yes.
What is it?
It's describing the property. The number is 508-649.
49. My exhibit 1, Mr. Reedman, says 508-648.
So does hers.
Yeah. It might be better. Is it possible we can do this in person?
She is in San Diego and is 96 years old, and I didn't want her to have to travel.
Can we, I don't have a problem if we're doing it by Zoom, but what I want is for everyone, the court, the witness, and the attorney to be on the same page as to what document is being displayed and offered and she's testifying to it. I think because we're not able to share our screen, that may create a little bit of confusion.
We can share our screen here. Let us try that. Can you see that document?
Your Honor.
So I see something that is different than what I have down as 1. I believe this might be 1. Well, I don't know what page you're on.
Let's go to the very top.
That's a different document, 649. A different document.
So that it continues.
Your Honor, it's where he started was in the meets and bounds description of the property, which is on page 3 of that.
We're not.
Oh, that's exhibit 2. I'm sorry.
So you want exhibit 1.
Oh, I see. Okay. So this is the first page of the document? Okay. I don't know if there's any way to reduce the size of that, but you can proceed, Mr. Reed.
Can you, Eric, move that up to the top of it, of that page? Okay, Miss Chris, who is Josephina Baisa?
Pardon me?
Could you repeat the question?
Who is Josephina Baisa?
That is my mother.
Okay, and this says that Josephina Baisa has given, granted, and conveyed to my daughter Gloria Chris a certain property, 4.045 acres, out of the A.F. Miller survey number 214.
Correct.
Can you explain to the court what this document is doing?
It's giving me the property in Texas to me.
Okay, and this is half of 125 Thunderbird?
Yes, correct.
Is that enough, Judge?
That's fine.
Okay. And your mother transferred this property to you back on February 26th of 1974. Does that sound about right?
That's right.
Okay. Your Honor, I would offer Exhibit 1 into evidence.
Exhibit 1 is admitted.
Now, can we move to Exhibit 2, Eric?
And whoever's operating the screen, can you maybe reduce the size of the document there? I think I see on your screen you have that plus and minus. Might make it a little easier.
Yes, Your Honor.
Thank you.
Okay, Eric, can you go to the top of the document?
Is that a little better, Your Honor?
Sure. Whatever your assuming that your mom is able to read. It just
Okay,
might
can you
help
read?
get more in the screen.
Can you read that?
Can I read that?
Yeah, just as.
Yes.
Okay.
Is it big enough? Thank you.
Yes.
Okay.
Okay. Can you move it to the top of the screen, please? Thank you. Okay. This document, again, is Josephina Baisa transferring some property. It's a different property. It's 0.4967 acres out of the same survey number. And this is being transferred apparently by these presents to give, grant, and convey to my son, Ruben O. Montelongo. Who is Ruben O. Montelongo?
Ruben Montelongo is my brother.
Okay, can you speak up a little bit? We can barely hear you.
Ruben Montelongo is my brother.
Okay, and in this Exhibit 2, it appears that your mother is conveying some property to Ruben. Did that happen?
Correct.
And is this document conveying 0.4967 acres out of the same survey to your brother?
Yes, Your Honor.
Okay. This is, as far as you understand it, the other half of the property that we've identified as 125 Thunderbird, correct?
Correct.
Okay. Your Honor, I would offer Exhibit 2 into evidence.
Admitted.
Can we move to Exhibit 3 now, Eric?
I believe it's this one.
Yes. Thank you. Ms. Chris, that document that we're looking at, Exhibit 3, says Ruben Montelongo at the top of it. Ruben's your brother still, correct?
Correct.
And this says that he is transferring as grantees, your grantor, he's the grantor. He's transferring to George Chris and wife Gloria Chris some property. Is that correct?
That's correct.
Okay. And you bought Okay, can we go down to where the legal description is on this page? There it is. That 0.4967 acres, that, as you testified a minute ago, is the other half of 125 Thunderbird in El Paso, Texas, right?
That's correct.
That's the half that your mother gave to your brother, Reuben,
Yes.
right? And by this, you and your husband, George, purchased Reuben's half of 125 Thunderbird. Well,
That is
you
correct.
purchased it. Okay, you purchased it from Reuben, correct?
Correct.
And so now you and your husband, George, owns all of 125 Thunderbird. Is that accurate?
That's correct.
And this is the document, it's a deed that does that, correct?
Yes.
Okay, Your Honor, I would offer Exhibit 3 into evidence.
3 is admitted.
Okay, I'm going to save Exhibit 4 for later. Let me start asking some questions. Okay, so at this point, and this is 1977, which is when Exhibit 3 is dated. Eric, can you move down to the date? That's dated February 22, 1977. By February 22, 1977, you and your husband, George, owned all of 125 Thunderbird, correct?
Correct.
Okay. And after that, you and your husband, I'm just going to refer to you and your husband as Chris from now on, unless there's some specific thing that I need to change. Chris conveyed their interest into a joint venture. Is that accurate?
True.
Okay. And were there 5 joint ventures in the joint venture?
Yes.
And joint venture is kind of a partner. Is that how you understand it?
Yes.
Okay. And at that point, you and your husband, Chris, owned one half of the joint venture, and for the other 4 members of the joint venture, one of them owned 20% and the other 3 owned 10%. Is that accurate?
That's correct.
Okay. And you and your husband was essentially managing the property at this point.
Yes, absolutely.
Okay? And he became unhappy with the communications and some things that were happening. And so you and your husband bought out all of the other ventures in the joint venture, except for the Meeks family. Is that correct?
That's correct.
So at this point, the joint venture was owned 90% by you and George, your husband, and
Correct.
10% by the Meeks family. Would you
Yes.
agree with that?
I agree.
Okay. And at this point, the property had been transferred into the joint venture, correct? So the joint
Yes.
venture owned it.
Correct.
And you're the person that you and your husband conveyed that property into the joint venture,
Correct.
right? And so all of the other joint ventures essentially received their interest in the property from you and George.
That's correct.
Okay, it was owned by you to start with, you and George, and then it went into the joint venture from you and George.
Yes.
Am I saying that correctly?
Correct.
Okay. Sometime after this occurred, and it took a little while, it might have been years afterwards, your husband, George Christ, negotiated with James Meeks, who was the father in the Meeks family, that to buy out the interest that Meeks had in the joint venture. Do you remember that?
I do remember that, and it's correct.
Okay, did George and James, George, Chris, and James Meeks, with you involved, did they enter into an agreement for that purchase?
Yes.
And were you at the meeting when this was concluded?
Yes.
Okay. I understand that was in a lawyer's office somewhere. Is that right?
Correct.
Okay. And did you ever see a piece of paper that showed that Meeks transferred their interest to Chris?
I saw it.
I'm sorry?
I saw a piece of paper, yes.
Okay, but we don't have that piece of paper anymore, right? We don't know where it went.
Don't have it.
Okay, and that was an assignment of a joint venture interest, assignment by which Meeks transferred their interest in the joint venture to Chris.
That's correct.
Okay. Did you pay $30,000 to Meeks for their interest?
Yes. We gave him a check for $30,000.
And Meeks took the money?
He did.
Okay. But as far as there was a piece of paper doing that transfer, but we don't know where it is at this point. It's been 25, 30 years at this point.
That's true.
Okay. And after that occurred, did you and your husband assume sole control over the property?
Yes, we did.
Okay. For the 25-year period, approximately after the transaction did place, did you manage the property, you and your husband?
We have managed the property.
Did you pay all the costs of the property?
All of the taxes and expenses for the property, yes, sir.
Okay. Did you collect all the rent?
Yes.
Okay. Did anyone from the Meeks family ever contact you to ask about the expenses or income generated from the property?
No one has ever contacted us.
Okay, and they never contacted you to talk about the operations of the property after you bought them out, correct?
Correct.
There was a debt owed on the property. It was owed to Montwood Bank. It was originally $330,000. That was probably a construction loan. Do you recall that?
Yes, I do.
Did you sign on that note?
Yes.
Okay. After Meeks sold their interest in the property to you and your husband, did they ever contact you about making a payment on the debt?
No contact whatsoever from the Meeks family.
Okay, and who made the payments on that debt?
My husband and I made the payments.
Okay, so at this point, it appears that everyone assumed, and there was some paperwork done, you said that the Meeks had transferred their interest in the property to you and George. Would that be accurate?
Yes.
Okay. And so you became the sole owners of the property at that time, being the only members of the joint venture.
That's correct.
Okay. And Meeks was paid for their interest, right? They got $30,000.
Yes, indeed.
And that check was cashed, I assume.
Yes.
Okay. Through your lawyer, you contacted Mark Meeks, correct? You remember that? Okay. And who is Mark Meeks?
Mark Meeks was.
Can you speak up a little bit?
Hold on a second. Hold on a second. Hold on a second. I understand, ma'am, that you have someone assisting you there, but when you are asked questions, that needs to come independently from your recollection, not asking anyone in the room with you to remind you of an answer. I need to know directly from you, okay? So, Mr. Reedman, would you re-ask your question, please?
I said, do you know who Mark Meeks is?
Yes.
Okay, who is he?
Well, the son of Mr. Meeks.
Okay, and Mr. and Mrs. Meeks at this point have both passed. Is that correct?
Correct.
And Mark Meeks is the personal representative of their estates.
Yes.
As far as you know, correct?
Yes, correct.
Okay. Okay. We sent a couple of letters to Mr. Meeks, to which he didn't respond. Is that correct?
That's correct.
These were all done by me, and you got copies, and we filed a lawsuit, this lawsuit that we're dealing with, correct?
Correct.
And we filed this motion for default that we're dealing with today, correct?
That's correct.
And copies of all of those have gone to Mr. Meeks, correct?
Correct.
And we sent a notice of this hearing today to Mr. Meeks, correct?
Yes, correct.
Okay. And I filed a copy of that notice with the court.
Correct.
Did you ever hear from Mr. Meeks regarding this lawsuit or this hearing?
I have not
Okay.
heard from Mr. Meeks.
Your husband passed away about 1999. Is that accurate?
That's correct.
Okay. And after that, did you assign your interest in the property, yours and George's interest in the property, to the Chris Credit Shelter Trust?
Correct.
Okay. And if you could, Eric, if you could pull up Exhibit 4. That's it. That's one page. Ms. Chris, can you look at page 1 of Exhibit 4, which you signed as the independent executrix of the estate of George Chris?
Yes, sir.
This appears to be a transfer of George's estate's interest to the Chris Credit Shelter Trust.
Correct.
And he assigned his interest in the Chris
Yes.
joint venture. Okay. You recognize that document? You signed it.
I do.
Okay. And if you could, Eric, move on to page 2. On page 2, you also signed that one on the same day. And in this one, it appears that you are assigning your interest in the joint venture to the estate of George Chris.
That is correct.
Okay, and I'm assuming these were done for you by Karen Carson, who was your lawyer at the time?
Yes, sir.
Okay. And so by these two documents, it appears that you transferred your interest in the joint venture, in Chris joint venture, to the estate of George, your husband, and then as the independent executrix of the estate, you then assigned the entire interest to the Chris Credit Shelter Trust. Does that make sense?
That's correct.
Okay. I would offer Exhibit 4 into evidence, Your Honor.
Exhibit 4 is admitted.
Okay. So after these transfers, as far as I can tell, the sole owner of the property would be the Chris Credit Shelter Trust. Would you agree with that?
Yes, sir.
And at this point, the Chris Credit Shelter Trust owns the property at 125 Thunderbird.
That's correct.
Okay. Your Honor, I'll pass the witness.
I don't have any questions for Ms. Chris. Do you have any other witnesses?
I do not.
Thank you very much, Ms. Chris. Anything else, Mr.
Thank you,
Reedman?
Your Honor.
Anything else, Mr. Reedman?
Your Honor, I've got a fairly lengthy argument that you probably don't want to hear.
I'll hear it.
The basic facts of this matter is that Gloria Chris owned the property originally. We've been through that by the testimony. All of this comes from the testimony of Miss Chris, and she also has an affidavit that was attached to the motion. And she and her husband became the owners of 125 Thunderbird. They then transferred the property into a joint venture. They bought out everybody else in the joint venture except for the Meeks, and then they bought out the Meeks at a later time. And then after her husband passed away, Gloria Chris conveyed the property from the joint venture to the Chris Credit Shelter Trust. This is a trespass to try title case. What we have to prove are two things. One, the contesting owners, and there aren't any contesting owners here, but the contesting owners of the property obtained title from a common source. And two, the plaintiff has a superior title of that of the contesting owner. The plaintiff is the Chris Credit Shelter Trust. The defendant is the Chris Joint Venture. At this point, we're from the documents that I provided, and I didn't have the joint venture assignments because those are documents that don't have to be filed and they've faded away into history somewhere. But the property at this point is owned by the Chris Credit Shelter Trust, and there's no one contesting the current ownership of the property. And Chris is the source of the property's title in the joint venture, as she and her husband conveyed the property into the joint venture. And they're also the source of the trust title, as Gloria Chris, for herself and for her husband's estate, conveyed the property into the trust. And there's no question there that the Chris's are the common source for the title, both in the joint venture and in the Chris Credit Shelter Trust. I would assert that it's also clear from the testimony that the trust's claim to the property is superior to the claim of the joint venture, as Chris in 2000 was the sole owner of the joint venture. And when George Chris passed away, the property was conveyed into the trust, meaning the trust has the superior title at this point to the joint venture. No contrary evidence has been presented, and notice has been given several times to Mark Meeks, who's the representative of the Meeks, both of the Meeks estates. I contacted him by mail twice prior to filing the lawsuit, explaining what our position was. And after filing the lawsuit, a lawyer in Fort Worth contacted me. The lawyer indicated very strongly that he was not Mr. Meeks' lawyer, but that he was a friend, and he was asking me if they could have some more time to file an answer. I've agreed to that, and there was a discussion with him with regard to what the claim was and what we were doing. And I contacted that lawyer again before we filed the lawsuit. No answer was ever filed. As we've been through with the testimony, Mr. Meeks was contacted again 3 or 4 times after that point. And it appears at this point that the Meeks family is not contesting the Chris claim that the Chris Trust owns the property. This lawsuit had to be filed in order to clear up title of the property. The problem with the title is that when Chris bought out Meeks, they bought a joint venture interest. A joint venture interest is transferred by an assignment, or at least it was in this case. And the assignment does not need to be filed. Over the 25, 30 years, it's probably more than that since it was the mid-80s. Since that assignment was signed, and I don't know what lawyer's office that was signed in, but apparently that assignment is lost somehow. It's misplaced or lost. But with the lawsuit, what we're asking for is simply a determination that the trust owns the property, and there isn't any party here that's asserting otherwise. We're simply asking the court to grant a judgment in order to clear up the title to this property in the Chris Credit Shelter Trust.
And so the court does have, and we'll take judicial notice of all the documents in the court's file, reviewed the motion, the attachments to the motion, and of course, admitted all those 4 exhibits in the hearing today. I have the originals here, Ms. Garaveo. Judgment is granted, and I have signed off on the proposed order. It will be filed with the papers of the court. Is there anything further?
I have nothing further.
Thank you very much. The hearing is adjourned. Thank you for your time.
Thank you very much. Thank you, Ms. Chris.
Thank you, and thank you, Your Honor.
Have a good day. All right, Mary. I have just a manila folder here that has what he provided, those original certified exhibits, and then
Okay.
Marissa, I signed off on the default that's here. Okay.
Okay, I'll go pick it up later. Judge, in the afternoon, do you also need me for the tax cases?
We may, yes.
Okay, so I'll just log on. Is it the same Zoom ID? Okay.
Thank you.
Okay, we'll see you then in the afternoon.
Bye-bye.
Thanks. Bye-bye.
Judge, we also have one. Good. Let me ask the judge, did she have one more? Let me ask her.
Oh,
real
okay.
quick.